WashingTECH.
So if you're looking at this for your company, you want to make sure that you are staying sufficiently informed about privacy developments, even when they're occurring in other topic areas.
Are you worried about your kids' safety on the internet? We are here to help. WashingTECH's 5-step checklist will take you through the process of protecting your kids, and will give you tips on how to set up the best parental controls for your children on their devices. You want what's best for your children. They deserve to be safe online. Our step-by-step guide will help you make sure they are. Download WashingTECH's online safety checklist today to protect your kids online. Find it at protectyourkids.online. That's protectyourkids.online.
Welcome to the Tech Policy Leaders Podcast.
The world's most influential voices keeping you safe and informed online.
Streaming from Washington, D.C., America's tech law and policy epicenter. These are your leaders. This is the podcast.
Tech Policy Leaders with Joe Miller, founder and CEO of WashingTECH.
WashingTECH, safe and informed since 2014.
My guest today is Mark Brennan, a partner at Hogan Lovells and leads their global technology and telecommunications industry sector group. He has a truly unique global regulatory and policy practice and advises clients on data protection, artificial intelligence, biometric data, and facial recognition, Internet of Things, and other technology and consumer protection matters. Mark Brennan. Mark, welcome to the show.
Joe, thanks so much for having me. How are you?
I'm doing well. So tell us about your career, Mark, leading up to your current role at Hogan Lovells.
Joe, thanks very much. And thanks again for having me. So I grew up in Florida with a business and communications background, and I moved to DC for law school. When I was starting my career, data protection wasn't really its own separate area of law. It tended to be something where there were bits and pieces, but you would combine it with other parts of your practice. So I came up on the communications and broadband side of the house, to start, I had interned at the FCC right when the Super Bowl wardrobe malfunction was occurring. I became immersed in the FCC sphere, things like wireless spectrum policy, broadband, net neutrality issues. And over time, I gravitated to more of the consumer-focused issues, e-commerce, internet law, online privacy, advertising and marketing, telemarketing and robocalls, those issues. And I developed my practice so that I was at the center of that intersection between privacy and communications law. So I could help clients navigate both the FCC issues and the FTC issues, or at the state level, the AG actions and the state PUC activities. Now at the firm, Hogan Lovells, several years ago, I became our lead innovation partner, responsible for developing and executing on our strategy for how we innovate in our client work, as well as how we innovate internally with our people. And in 2020, I became our global technology and telecoms industry sector group leader. And in that role, I'm responsible for our global strategy on how we approach these key industries and how we make sure that our clients and companies operating in these industries are keenly aware of all the ways that we can help them.
That's interesting because this area has expanded so much beyond just talking about media and technology and social media firms. I mean, Target had their data breach a handful of years back, which exposed millions of shoppers' credit card information. So retailers are required to adhere to the same privacy provisions. And in late August, as a matter of fact, the state of California's Attorney General's office entered into a settlement with Sephora, the cosmetics outfit, with 2,700 stores worldwide over allegations that Sephora violated the state of California's Consumer Privacy Act, which went into effect in 2018. Tell us about what happened in that case.
Well, you're exactly right. In an environment where it hasn't been a slow decade or a slow year, this summer has been a particularly active news window for U.S. data protection, privacy, cybersecurity developments, and other tech-centric issues. So, with respect to this Sephora settlement, just for those that may be less familiar, the California Attorney General enforces the California Consumer Privacy Act. So this is the existing California state law that we view as a comprehensive privacy law. So it has transparency and notice provisions. It has consumer rights. There are different enforcement provisions and some other things. But ultimately, this has been a key driver of a lot of attention in the privacy legal space over the past few years. And as part of its efforts to enforce the CCPA, the Attorney General and the Attorney General's office has issued a series of letters since 2020 to companies that are alleged to be violating different provisions of the CCPA. And sometimes these seem to be driven as individual target companies, and other times there seem to be waves of letters that go out to companies that perhaps raise a similar compliance issue. Some of these are efforts where the AG's office might be looking at various websites and seeing some language and have questions about it. But again, these have been done in a variety of waves over time, and it seems like Sephora first came onto the AG's radar during an enforcement sweep in 2021, which was looking at the extent to which retailers or other companies were effectuating a global privacy control, GPC. And this can mean a variety of things, but for our purposes today, think in terms of a mechanism that allows you to opt out of certain uses, transfers of the data, without having to go into, company by company, website by website. So you opt out through the GPC, and it is then communicated to individual businesses. And the core provision that they're expected to implement is to stop selling your personal data. And there are specific definitions in California and so forth, but that's the key impact. So you opt out from further sales of the data.
And so what happened in this case, Mark? Do you have any insight into what the state of California found that Sephora did wrong?
Yeah, it's really interesting. So, of course, as part of an investigation, we don't get all the details, but it appears that as they were investigating Sephora's website, the AG found that activating the GPC had no effect, and that the data continued to flow to third-party companies. So it seemed apparent that sales could be occurring. They also raised some concerns about language in the Sephora privacy policy that stated that Sephora does not sell personal information. But then there was other language that seemed to be perhaps in tension with that, sharing consumers' geolocation data, other electronic network activity, and other pieces where the AG reached out to Sephora and with all this information, sent them a letter as part of the enforcement framework for the CCPA. Parties that receive a notice of alleged violation have 30 days to cure the violation. And based on what the AG had put forward in the settlement and then the associated releases, it appears that Sephora did not cure the issues that the AG had identified.
WashingTECH Tech Policy Podcast, the inclusive voice of tech policy.
And this was the first public CCPA case resulting in a monetary penalty. What did it entail exactly?
Yeah, that's exactly right. So this is the first instance where we've seen a public settlement, and the first time there's a financial penalty that's been announced. Now, we know that the AG's office has been engaged in a series of investigations. So a lot of companies have received letters over time. Presumably, many of them have cured the violations or alleged violations in 30 days, and other investigations may remain pending. For this settlement, I think there's some very interesting takeaways. So as part of the agreement, there's the $1.2 million financial penalty, but then there are also some injunctive terms and reporting requirements imposed on Sephora. So on the injunctive terms, I think it's not very surprising. The injunctive terms really get at Sephora being required to fix the things that the AG had thought were not correct in the first place. So clarifying the online disclosures, making sure that they honor the impact of the global privacy control, and making sure that their contractual agreements are updated to reflect certain requirements that the CCPA imposes. So you have to have certain language to make sure that the parties that you share the data with are limited from using it for their own purposes and other provisions. So the injunctive pieces are in my view things that you would expect companies to be doing as part of their compliance efforts anyway. But the reporting requirements alongside the financial penalty are notable. So going forward, and it looks like 180 days within after the settlement, and for 2 years after, Sephora has to provide reports that detail their interactions and honoring of the global privacy control, the testing that they've done, the monitoring that they do to make sure it's working, any analysis of technical errors and other things, and then also a report on website and app reviews. So the entities that they make data available to, the extent to which some of these third parties are being set up as service providers and rather than, as defined under the CCPA, third parties, contractual commitments, and really getting at making Sephora show its work going forward. So the AG's office is signaling through the settlement that they want to make sure that this corrective action is not just a snapshot, but one that the company continues to put sufficient resources to staying compliant going forward.
So what should be the main takeaway for other retailers, including smaller ones that don't want to face similar allegations of violating CCPA?
Yeah, well, I think there are a few. And like I said, we don't get all the facts. We only get the AG's press release and the details within the settlement itself. But as I read it, I think it's an important reminder for companies that are in a fast-paced environment, have introduced new products, have made additional features available on their website or through their apps to take a fresh look at their privacy policy, not only for compliance with the California Consumer Privacy Act, but also the upcoming changes in California privacy law that are set to become effective January 1st. You want to be ready for that. And several other states will be coming online with their own state privacy laws starting in 2023. So it's something to the extent you haven't already, the remainder of 2022 becomes an opportune time to take a fresh look and to make sure that your disclosures remain accurate. Double check with the business, make sure that the data mapping, the data flows, all check against what you're saying. And then alongside that, one area that I think was something that a lot of businesses put attention to when the CCPA first became effective was updating their agreements with third parties, their vendors, their business partners, to really make sure that they had this language. My experience has been that the AG is looking at this language and making, like I said earlier, making sure you can show your work that you have adopted this language for the agreements. And so it's, again, an opportune time to take a fresh look at the agreements with the parties with whom you share the data. And then finally, I think we also are given a reminder here that regulators, and this is not unique to California, it's not even unique to the US, but regulators absolutely are not viewing privacy compliance as a check the box exercise. It's ongoing. It's something that requires sustained resources, and companies need to be devoting sufficient attention to that issue. There can be elements of fatigue. I hear this from people in the ecosystem all the time, that there was a lot of attention on GDPR in 2018, a lot of attention on California, and that there's only so many times you can go back to management and say, yep, it's a big thing again, and we really have to get the resources. But the truth is, we're already seeing the enforcement, and the regulator expectations are that you will have put the resources and look, if nothing else, when you receive a letter like this from the AG, it's important to be prioritizing any corrective action to make sure you credibly fix things by the end of that cure period, the 30-day cure period that companies have under the CCPA. So those are a few ideas, but really some interesting takeaways from this one, Joe. Tech
policy touches every form of public policy these days. It's foreign affairs policy, it's competitive policy, it's consumer, it's retail policy. So thanks for shedding light on the retail side of things today, Mark. What are some final ideas you'd like to leave with us before we close, and where can we find you online?
Joe, thank you. So to find me online, I'm on Twitter at MWBrennanDC. You can also find me by my Hogan Lovells bio, and I'm on LinkedIn. Some other thoughts here. One thing that I think we should be prepared for as we look ahead, privacy as coming up through privacy laws. I think it's continuing to evolve, and we're starting to see where privacy is now becoming a key part of other types of laws. So for a number of years, it was always a privacy law. GDPR was a privacy law. California was a privacy law. But now we're starting to see other topic areas with sort of the headline, if you will, AI, algorithms, consumer protection, and on and on, but for which privacy is a key component. So if you're looking at this for your company, you want to make sure that you are staying sufficiently informed about privacy developments, even where they're occurring in other topic areas. And if you are at an outside counsel role, make sure that you're helping serve your clients by keeping an eye out for them and casting a wide net here for the issues that can affect companies. And we're also seeing this continued increase in the overall attention and spotlight for regulators. So I expect this will continue.
Mark Brennan is partner at the law firm of Hogan Lovells, where he leads their global technology and telecommunications industry sector. Mark, thanks for joining me.
Thank you, Joe.
WashingTECH.